Welcome back everyone to the Law of Tort. In this lesson what we're going to do is talk about some of the introductory principles of the Law of Tort, namely asking the question of what the purpose or the justification or the rationale for the Law of Tort may be. And this involves asking a question about the relationship between the concept of tort and some of the principles of compensation which exists. So, like I said, we're going to talk in this lesson about the concept of tort and the important rationale between the rationale behind, should I say, the nature of tortious liability. Essentially, we're going to be asking the question, why do we have the law of tort? What is the purpose of having the law of tort? And why is that purpose very, very important? Now, arguably the most important of the main justifications for the law of tort is the idea of compensation, the principle of compensation, as being the main justification for the imposition of tortious liability. Now, we'll talk about other reasons why you may justify the existence of the law of tort, but for the most part, this idea of compensation and principles of compensation really inform the fundamental bedrock and characteristics of tortious claims, and really show us where torts arise, how torts arise, and it will inform, for us at least, the principles of tortious activity, which lead us to looking at the different protected interests within the law of tort, and to talk about the various different kinds of torts that exist, which is going to be the topic of the next lesson. So fundamentally, we're asking the question, what is tort for? What is the purpose of the law of tort? Now, we noted in the previous lesson the definition of tort, a general definition, which is just simply the idea that we have civil wrongs which a claimant may be able to get some kind of compensation for, claim for damages, for example. And this is important for a number of different reasons. There is the idea here of wrongs, the idea of there being some kind of wrong that is done to an individual, and that individual can then claim a civil case, and therefore the defendant may be civilly liable for a particular damage that is caused as a result of the wrong that they had inflicted. So, for example, if an individual had negligently acted while they're performing their job, this negligent action causes some harm to you, there has been a wrong that has been suffered onto you. It was no fault of your own that you have now had some harm caused onto you. It was the negligent actions of the individual who were working in their job. And so the result of which is that you may have a claim in civil liability for that particular instance, and to essentially claim for damages as a result of that particular wrong that was done to you. And so the law of tort seeks to impose certain liabilities for action, for said action, in order to essentially rectify some of the wrongs which were caused by the action which was potentially negligent. Now, this is just using negligence as an example, because negligence is by far and away the most litigated tort. It is also one of the most important torts, and probably the one that every single law student begins with. We're going to begin with negligence in a couple of lessons' time. But there are obviously other instances. You have occupier's liability, nuisance, you have intentional torts, and you also have things like defamation, for example. Now, one of the things that is important is that tort has a number of different purposes and justifications, but they also have a number of different things that tort is not utilized for, or the rationale is not necessarily for this particular goal. So it does not necessarily suggest that tort imposes some kind of punishment onto the defendant. This is where you can make a delineation, for example, between the law of tort and the criminal law. The criminal law seeks to impose some kind of punishment onto a defendant who is found guilty of a particular offence. The law of tort doesn't do that. You may think that the resulting damages that an individual may have to pay, or the retraction of a statement that may have to be made by a defendant, is a kind of punishment. But the purpose of that particular imposition of damages isn't to punish the defendant. It's for compensation, which we'll get to in a second. So it means that this kind of idea of shaping society as a goal for tort doesn't really attract necessarily to the idea of tort more generally. So Whereas with the criminal law, you could make the argument that one of the purposes and one of the justifications for the criminal law is to try and shape society in a particular way and to try and control behavior in a particular way. The law of tort doesn't necessarily have that purpose. Tort is not necessarily justified on the basis that it should deter others from acting in a particular way. Now, this isn't to say that tort doesn't have that results. People may be deterred from acting in a particular way, or may be extra cautious in their performance of a particular action to avoid liability in tort. But the purpose here is that it's not necessarily the end goal of the imposition of tortious liability. So, for example, the mere existence of liability for negligence, for example, may deter an individual from acting in a particular way. It may make an individual who is working on a job where they have a duty of care to make sure they take extra care and they do not breach said duty of care. And so that might be something of a deterrence for individuals to make sure that they are trying to avoid tortious liability. But the fact here is that tort itself is more concerned with the position of the claimant. And this is where we get the idea of compensation and the principle of compensation. So when we look at tort, and when we look at a successful claim in tort by a claimant, it involves some kind of loss which is incurred onto the claimant. So, for example, if you have a negligence case, if you have an injury, a personal injury case, for example, the injured party is the claimant, and the person who is wronged in some way is the claimant in this particular case. Now, this could be more than just personal injury. So negligence often involves personal injury. It could also involve psychiatric injury, which we'll get to in future lessons. It may also involve, in some cases, economic loss, and we'll get to the limited circumstances where economic loss can be imposed. It may even concern reputational loss in the case of some kind of defamation claim within the law of tort. But the purpose of tort is to essentially rectify, insofar as possible, the loss in question, to try and rectify the position that the claimant would have been in if they hadn't have had this tortious activity imposed upon them, essentially, or subjected to the particular harm. And this really gets to this idea of the principle of compensation, the view that a claimant should be compensated for the loss which was suffered. And compensation will often, and most often, take the form of economic compensation. So, for the most part, there is the payment of damages, but it could also be other things. So, I've mentioned earlier on the case of defamation. When you have a case of defamation, there is often the payment of damages in some cases, but there may also be, in addition to this, a full and public retraction of the false claims that were made by the defendant. That's a type of compensation in a way. So if you make a false claim to the public and the individual has their reputation damaged as a result of this, you may be sued for defamation or may be threatened with litigation for defamation, and you may have to then retract that public statement that you had made. And that can be seen as a way of rectifying the kind of loss that was had if that particular piece of information that was false had continued to stay in the public domain without the rectification and the correction of the record. Now, the issue with the principle of compensation is this principle known, the Latin phraseology is restitutio in integrum, which essentially tells us that we want to compensate the claimant and bring them back to a position they would have been in, assuming that the tortious action had not happened. A very obvious example of this would be if, for example, you are a claimant and you have been negligently caused harm. So somebody has caused harm to you, and you have become injured as a result of someone's negligent action. And this harm and this injury means that you have been unable to work for, let's say, 3 weeks. Now, the compensation may be monetary payment, and the amount may be calculated on the basis of, okay, well, if you hadn't have had this injury, you would have been at work for this last 3 weeks, so we'll give you 3 weeks worth of pay, or you will get 3 weeks worth of pay as damages, as a result to try and essentially eliminate the conditions and to eliminate the consequences of that particular injury, to ensure that you have been brought back to the position where, assuming that tortious action had not happened in the first place. Now, that's a particularly good system, and it is clearly elucidated here in the case of Livingston and Royall's Call Corporation from 1880, when they say that compensation should take the form of the sum of money which will put the party who has been injured or who has suffered in the same position as he would have been if he had not sustained the wrong for which he is now getting his compensation or reparation. So that's the basic way in which we understand compensation, the principle of compensation within English law, specifically within the law of tort. It elucidates this principle of restitutio in integrum. When we look at how we apply this, however, to real cases, how effective can that actually be? There are situations where it is not particularly effective as a way to remedy particular torts. And we're going to get to this when we go all the way to the end of our lessons on the law of tort, because we're going to talk about remedies and damages and compensation principles in more detail. But it was worth noting that in this first early lesson that we just overview it quite briefly so we understand what the purpose of tort is. But we're going to get into all of this in more detail in future lessons' time. But for example, in the case of personal injury claims, it might be the case that in reality there's not that much monetary compensation that can truly remedy the wrong which was committed. So if something leads to the loss of life or permanent change to one's life, permanent brain damage, for example, a loss of a limb, for example, all of these things, you can't rectify that with a particular financial sum. So taking monetary compensation, taking a financial sum and trying to apply that to every single type of case within the law of tort may be difficult to do. In the case of defamation cases as well, you might have an instance where a retraction and damages is what is issued by the courts, but that doesn't necessarily bring the claimant's reputation back to where it originally was, because there might even still be people who believed the defamatory claims, regardless of if that statement had been retracted. And so this idea of no smoke without fire is obviously something that is quite difficult to shake off when you are being met with defamatory claims. So compensation isn't necessarily effective, and it's not necessarily an all-encompassing, perfect one-to-one comparison that you can essentially just throw money at a problem, and therefore we can bring that individual back to where they were if the tort had not been committed. But it is essentially the best that the law can do in terms of bringing back and bringing things back to how they would have been if that tort hadn't have been committed, even if in a lot of circumstances, or maybe in certain circumstances, it's not necessarily that effective. There's also the problem that the law of torts is reticent of the possibility that compensation may be indeterminate or even disproportionate. So there's a problem of being able to essentially allow for compensation, but to actually have a fixed number for compensation, and to ensure that the compensation isn't too much compared to the damage that was caused by the particular tort. We'll get into this when we look at the policy prescriptions around the idea of floodgates litigation at the end of this series of lessons. But for now, the next lesson is going to look at the different types of tort and look at the different kinds of protected interests within the law of tort before we move on to actually looking at the substance of the law of tort, beginning with the tort of negligence.